Hey everyone, Rob Ryder here. It's Monday, March 12th, 2012. Assignments. Good stuff, pay attention. Assignments and contracts. In common parlance, the word signifies the transfer of all kinds of property, real, personal, or mixed, whether the same be in possession or in action. As a general assignment, in a more technical sense, it is usually applied to the transfer terms years, but is more properly used to signify a transfer of some particular estate or interest in lands. Now, we're looking at this as it has to do with your real estate for today, which is the house that you live in. The proper technical words of an assignment are assign, transfer, or set over. But the word grant, bargain, and sell, and other words do the same thing. So if you have a piece of paper with those words, you just made an assignment, or something was assigned to you. Uh, Chosen action cannot be assigned to law. Okay. But it may be done in equity. Ain't that interesting? The deed by which an assignment is made is also called an assignment. So even though it's called a deed, because it's an assignment, it's called an assignment. But your piece of paper is going to call it a deed. By an assignment of a right, all accessories which belong to it will pass with it. If the assigner of a bond, we're going to find out that in this case it's them, had collateral security or a lien on the property, the collateral security and the lien will pass with the assignment of the bond. So who did they as? So if you have an assignment, an assignor gives it away, and an assignee gets it. Well, I wonder who the assignee might be. The assignment of a thing also carries with it all that belongs to it by right of ascension. If therefore the thing produced interest or rent, the interest or arrearage of the rent, since the assignment will belong to the assignee. It'd be good to be the assignee. Let's go see how we do that. All right, so this is the state of Delaware. I'll send a link to it, but it's got some pretty good information. I got to look at some of the other sections in it. It's their Title 10, Courts and Judicial Procedures, Special Proceedings. Now, please understand the reason they call it special proceedings is because they're not general proceedings, and general proceedings proceed in due form of law. In other words, they're lawful. So special proceedings aren't necessarily lawful, but they'll proceed anyways. Voluntary assignments. So when you sign a deed of trust, grant, convey, bargain, sell, all these words, you're assigning a portion of an estate to whoever you just gave it to. Now, that estate isn't just the real estate, the house that you've put on this deed of trust slash mortgage that you're putting up as collateral. It also has to do with the money you're putting in escrow, which is a security until you pay the deposit or the mortgage, because you've allowed this piece of paper to be deposited. It gives the depositor a equitable mortgage over it. Equitable mortgage means legal title. Guess what? They got legal title over the deed of trust simply for having it on deposit, even if you don't own any money. Now, we don't owe any money because if you look at any deed of trust that you have, the lender slash beneficiary slash whatever they would be called has never acknowledged the deed of trust. And I did a video on this some time ago. Because they haven't acknowledged the deed of trust, you can revoke the deed because basically you don't have to revoke it, it just never happened. So they have never lent you any money. However, you did agree to let them deposit something. Now, I don't know, let's use this as a scenario. You're at the closing table. Everyone's done, shaking hands. Okay, we'll go ahead and make this deposit for you. You thinking it's the promissory note or something else, you say fine. Well, guess what? They deposited many things, and by merely having it on deposit, you have given them an equitable mortgage over the property. But so we need to find out we'll get it undeposited. But in this case, special proceedings. So this is in court, in Delaware. Filing, which is a deposit. Inventory of property assigned. In in every case in which any person makes a voluntary assignment, that'd be a deed of trust or a mortgage, where you sign it voluntarily, of his or her estate, real or personal, or any part thereof, to any other person in trust. So when you give it to them, you're giving it to them in trust to hold it for his or her creditors, or some of them, for his or her creditors, or some of them. The assignee, the person that we give this to, within 30 days after execution thereof, shall file in the office of the Register and Chancery, Circuit Court Clerk, of the county in which the real or personal estate of the assignee or you is situate, an inventory or schedule of the estate or effects to be assigned, and accompany with an affidavit by such assignee, and that would be them, that the same is a full and complete inventory of all the estate and effects so far as the same has come to his or her knowledge. So within 30 days of an execution, so since this can be done with a verbal agreement where the dude says to you, well, I'll go ahead and make this deposit. You say, fine, go ahead and do it. And then he does it. Well, he just executed the verbal agreement you had between you, each other. So within 30 days of that, he has to go to the Register and Chancery, who here in Michigan is a circuit court clerk of the county where the real or personal estate is, an inventory or schedule of the estate or effects so assigned. So what's just been assigned. So I'm going to say for your house, this is in the county where you live. However, for your body, it's in the county you were born. I don't want to get too much in the body end. Let's just concentrate on the houses for today. So what's an assignee? A party which a transfer of property, rights, or interest is made, one appointed to act for another, a deputy or agent. Well, guess what? You appoint them by telling them, yeah, go ahead and deposit that. They just became your agent. When the inventory is made of goods and estates assigned or conveyed in trust, it must include all the property conveyed. So we're going to make this assignment. Again, they're going to go do some work, 30 days. They shall file in the office of the Register of Chancery. I'd be going talking to this person, the circuit court clerk, right? An inventory and a schedule of all estates or effects so assigned. I would be asking for an inventory or schedule of all estates or effects so assigned, accompanied with the affidavit by the assignee. That's what I want to see. And show them a copy of your deed of trust. And ask them if they may have a copy on file too. Schedule, practice. When an indictment is returned from an inferior court, obedience of writ or certoria, the statement of the previous proceedings sent with it is termed the schedules. So they said up here, I mean, that's the word out of Bouvier's for schedule, and they said in here, did it say, come on, where's schedule? So it's either an inventory or a schedule, right? So either what's in it or the schedule, which will be the proceedings that you have gone through, you may not even know have happened, on an indictment. And an indictment is a summons. So this is after they, if you looked at the one I did in an indictment, we're not talking a lawful indictment. We're talking some fictitious bullshit indictment that they're doing. They won't have ever an affidavit under penalty of perjury to substantiate their claim. Schedules are also frequently annexed to answers in a court of equity and a deposition of other documents in order to show more in detail the matter they contain and should otherwise be conveniently shown. Okay, so schedules and to the deposition of other documents are going to have much more detail than we may have seen because they don't want it to be convenient to be shown. Okay, so now this dude, after 30 days, or within 30 days, is, he's I'm sure he's done this. He's filed an inventory of the property assigned, which is what's on your deed of trust. So show the clerk your deed of trust. Say, I'd like to see the file for this. Appointment of duties of appraisers. Upon the filing of an inventory, an affidavit required by the Court of Chancery shall appoint two disinterested and competent persons to appraise the estate. So these guys have no skin in the game. Somebody's going to come in and make a deposit, or someone's going to come in and file this inventory, and the title examiner is going to look at it. Who shall, after being duly sworn and affirmed by some person having authority to administer oaths, so done it under oath and under seal, they've gone in front of a judge, they have an oath, to perform their duties with fidelity, forthwith proceed to make a appraisement of the estates and effects assigned according to the best of their judgment, and having completed their same, shall return the inventory and appraisals to the office, the register, and chancery of the county. Again, that's the circuit court clerk in Michigan. And it sounds like she's got lots of good information that has to do with your deed of trust already on file, because within 30 days of you assigning it, they had to do an inventory and put it in a record, in which the inventory of the assignee and the affidavit accompanying the same were filed. The appraiser shall receive the same compensation as it now allowed by law appraises the estate of the decedent. So this paperwork doesn't sound like you're going to find it in the Register of Deeds. You're going to find it in the clerk of the court's office. And we keep going to Register of Deeds looking for things, but that's just for the land. This particular deed of trust isn't for the land. It has land as collateral. It's for the escrow. It's for your estate from your landed estate. Assignee's bond. The assignee shall, as soon as the inventory and appraisement required of this title have been filed, give bond with sufficient surety to be approved by the Court of Chancery in the amount fixed by the court, being not less than or total amount of the inventory and appraisement of the estates so assigned. So you've assigned your stuff. They've done an inventory. They come up with an amount. Now the guy that you assigned it to, like the bank, has to put up a bond along with an affidavit under penalty of perjury. The bond shall take into the bond shall be taken in the name of the state. I believe they're talking about you. And the condition thereof shall be as follows. The condition of this obligation, so it's an obligation, is such that this obligation, again, is put in by them. Right? They're the ones making the obligation. The condition of this obligation is such that if the above bounden assignee of whatever it is shall in all things comply with the provisions of this chapter and shall faithfully execute the trust confided in him or her, then the above obligation to be void, otherwise to remain in full force and virtue. So they put this play, they've just made their play right now. They need to execute it to the end. If they can't prosecute this and finish whatever the agreement of the trust is, and, I don't think we see all the paperwork, right? So you get the bond. So this is when they've taken you into court, I mean, the bond may be there it's supposed to be in there within 30 days after being put in. You can go claim that property, and I think you're going to get the bond. But if they cannot execute the trust, so in other words, if we get to the court proceedings and you stop them there, then that bond is yours. That's what I'm saying. There's this security out there that they've had to put up, and we need to go grab it. To the bond there shall be subjoined, added at the end, a warrant of attorney to confess judgment thereon. And the bond and warrant shall be joint and several. And such bond shall be filed in the office, the Register of Chancery of the county in which the inventory and appraisement were filed, and shall inure to the use of all persons interested in the property assigned. So this bond and this warrant of attorney with a confessed judgment on it, saying that the attorney, as we'll see, well, let's look what a warrant of attorney is, a written authorization that allows an attorney named in it to appear at the court and admit the liability of the person given the warrant. So we're not given this warrant, somebody else is. And now the attorney has to admit their liability um, if it comes down to that. They haven't had to do that so far. And shall inure, so what does inure mean? To result, to take effect, to be of use, benefit, or advantage to an individual. Right? So the bond is made out in your benefit. This is simply law. If somebody is going to bring a claim against you and your property, they have to put up a surety in case they can't prosecute their claim because they brought in an innocent man and charged him. Well, then the frickin' plaintiff pays. It's kind of the way law is supposed to work. Commonly used in legal terminology, the phrase to inure the benefits of Janet Jones. So, anyways, this is all supposed to be written on this paperwork that we're not seeing. That's my point. There's a bond sitting back there that's been filed. This reads like it may not have been filed in the same file, but somehow they are going to be joined. You got a file for the deed of trust, but where's this warrant of attorney to confess judgment with the bond? So, clerk, I accept your oath, bind you to it, remind you have a fiduciary duty to me. I ask you not to be a concealer, and I extend you my sovereign immunity. I'd like to know where B is. Well, what's B? To the bond there shall be a subjoined, added at the end, a warrant of attorney to confess judgment thereon, and the bond and warrant shall be joint and several. I'd like to see that bond. It has something to do with this deed of trust. I'd like to see that file too if they're in different files. Okay, so this writing is usually given to help ensure that the person signing it will pay the amount that he or she would be obliged to pay if a judgment were entered against him or her. It usually contains an agreement that no action will be started against the signer if the obligation described in the paper is satisfied. So in other words, if they can execute the trust, then there's no obligation because it did what they said. If they can't execute it, then you get the bond. Essentially, the warrant of attorney is a cognate note that permits the confession of judgment, a shortcut to obtaining judgment against a debtor that is now illegal in most states. Well, unfortunately, they say you can use it. Proceedings on bond. Upon the application of any person interested, the Court of Chancery may direct the bond provided under of this title to proceed on if it's deemed necessary and proper for the protection of the interested parties. So go find out how to apply. Upon application of any person interested, well, you're certainly interested. You're the interested party in this transaction. Or ask them if you need to put in a plea of the crown. Assignees' accounts and exceptions. The assignee shall. Now you have to remember, right? We got two pieces of paper going here, and they're both assignments. One is you assigning the deed of trust to them. The other one is them assigning a bond to you. That's yours if they can't execute the trust. However, we're the assignee. They're the assignee on the deed of trust that we've given them. They've had to file it within 30 days, have an inventory done, checked by two examiners, an amount put in, and then they put up surety. That includes a warrant of attorney. And the warrant of attorney is to confess judgment. And to confess judgment means to admit the liability of the person's giving the warrant. And again, they're giving it. We're not. Okay, so proceeding on the bond, okay. assignees' accounts and exceptions. The assignee shall render an account of the assignee's trusteeship every year. So now we're talking about the guy who gave the bond, and he has the trusteeship every year from the date of the assignee's bond required under whatever section of this title before the register in chancery the proper county. So every year that they have this, they have to go and render an account until the trusteeship is closed. So how much money does that account make in the year? They have to come and put it in the record. And a final account rendered and approved. If the assignee fails to perform this duty, the register in chancery may issue a citation to such assignee requiring the assignee to appear and exhibit under oath, affirmation, accounts, trust within certain time to be named in such citation. So, one of the things you're going to be looking for when you get in here is, hey, where is the yearly rendering of the account by the assignee of the bond? Upon the filing of any such account, notice thereof shall be given to all persons in interest as directed by the appropriate order of the Court of Chancery. So upon the filing of any such account, notice thereof shall be given to all persons in interest. See, I wonder if this is something to do with the tax stuff we get every 6 months. Somehow they're letting us know that this, you know, everything they do has to be done lawfully, if not only lawfully because you haven't bitched. And that's the thing about the law. If you don't complain about it, I guess it's lawful because it's just the custom of the time, and you're going with the custom. Well, change the custom. So upon the filing of any such account, notice thereof shall be given to all persons of interest. So somehow they're letting us know whenever they do this, upon the filing of any such account. Such order and notice shall set forth the time in which any person in interest may take and file with the Register of Chancery in the proper county exceptions to the account in question. Exceptions. I wonder what those are. The time within which exceptions to any such account may be filed by any person of interest shall be determined by the court in the exercise of its discretion, and may be extended from time to time for good cause shown. Any exception so filed in respect to any such account shall be heard, determined, and a particular account adjusted before the court, as it may order or direct. And in law, may means shall. They shall order and direct. This term is used, so exception, this term is used in the civil nearly in the same sense as the word plea in the common law. Well, we are going to use it as a plea in the common law because a man always goes to common law because a plea of the crown, as interpreted by Lord Coke, and his Institutus of Laws, Book 2, Chapter 11, Court of Common Pleas, when he talks about when they set this up under the Magna Carta, forgetting if you believe the Magna Carta is lawful or not, doesn't matter. What does matter is Lord Coke's book is considered a book of authority brought into court, is the law. And he says in there that when they had this split up of the king's bench, let's call it that, where everything was before the king, and now the king wasn't always there. They said, well, we're going to take our court and we're going to put it one place. The king's always leaving and going on a crusade. And we're going to call it the Court of Common Pleas. And that's where the Court of Common Pleas was set up in one particular place. The king's bench always follows the king. You're the king. The king uses a thing called a plea of the crown. It's used for all criminal or mortal matters. M-O-R-T-A-L. Mortal means man. They're talking about you. That's what you're supposed to use. So in chancery practice, it's an allegation of a party in writing some pleading or proceeding cause is insufficient. Yeah, this get all messed up like this. Okay. So removal of assignees. The Court of Chancery, upon cause being shown, may remove the assignee or trustee referred to in this chapter and compel an assignment of the trust estate to the others appointed in their stead. Any order of the court in the premise may be enforced by attachment and imprisonment. Ain't that wonderful? So how do we get them bastards off our paperwork? Because right now, they're the assignee on the deed of trust. Well, the Court of Chancery, upon cause being shown, they never signed the agreement. may remove the assignee or trustee referred to in this chapter. They're gone. And compel an assignment of the trust estate to others appointed in their stead. Tell them you want it. Any order of the court in the premise may be enforced by attachment and imprisonment. Void preferences of creditors. Whenever any person in contemplation of insolvency, so you're thinking about going bankrupt, or in contemplation of taking benefit of any insolvent laws of the state, I wonder they're talking about them taking benefit, makes an assignment of his or her estate or effects for the benefit of the creditors, and by such assignment, either under its provisions or likewise, prefers any creditor to others, or in any such assignment secures or pays to any creditor a greater portion of his debt, his or her debt or demand, than shall be secured or paid to all. Every such assignment so giving a preference shall be deemed fraudulent and absolutely void. This has to do with the bankruptcy. This is interesting stuff too. And the estate or effects contained therein shall be liable to be taken in execution or attached for the payment of the assigner's debts, as fully as to such assignment as has been made. And whoever makes such a fraudulent assignment shall forever be deprived of the benefit of an insolvent laws of the state. So, if you're going to go through a bankruptcy, and you know how much you're going to pay each creditor, well, if you don't pay them all the same, if you favor one over the other, you've just made yourself void of using the insolvency laws, and then they throw you under bankruptcy laws. So in insolvent, this word signifies several meanings. It signifies a person's estate is not sufficient to pay his debts. But I like this. A person is also said to be an insolvent who is under a present inability to answer, in which the ordinary course of business, the responsibility which his creditors may enforce by recourse to legal measures without reference to his estate proving sufficient to pay all his debts when ultimately wound up. That makes you an insolvent. You have no ability to answer. In the ordinary course of business, the responsibility which his creditors may enforce, that he answer by recourse to legal measures without reference to his estate proving sufficient to pay all his debts when ultimately wound up. They're not telling you, hey, you got plenty of money, come and pay this bill. No, you don't pay it, we're going to take the whole thing. For $10, whatever their little amount was, we're going to take all your stuff. We're going to take your house, your car, and. Oh, it signifies the situation of a person who has done some notorious act, you'll find out you did, to divest himself of all his property as a general assignment or an application for relief under bankrupt or insolvent laws. Well, you did a general assignment. This goes back to the video I did on registering your farm. When you apparently registered your farm, you put the whole estate into a trust. It's sitting on a shelf someplace also. And they have legal title, equitable mortgage, simply because it has been registered, which means filed, which means deposited. And deposit means if I have you deposit something for me, I give you something for a deposit, I've just given you an equitable mortgage over it, legal title. But there's an agreement to take it out of deposit. It isn't like they can keep it. No, there's an agreement. All you need to do is fulfill the agreement to take it out of deposit. Well, when we go back to the deed of trust, remember, they never acknowledged the deed. They didn't loan you no money. Therefore, the only way it can be sitting there is you just agreed to have it deposited, so now you want to have it undeposited. And I'd really, 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 really be talking to this register in chancery of the county in which inventory, the signee, and the affidavit accompanying the same were filed. The register of chancery, at least here in Michigan, and I'm sure it's going to be the same almost anywhere, because not every place has a court of chancery anymore. They've hidden them. 1846, the court of chancery was absorbed by the circuit court. And guess what? They made the clerk of the circuit court the register in chancery. Now, that doesn't just jump out in the Michigan statutes. You got to kind of look for it. I should have put that page up here. It's almost like a footnote. But it's there, and, that's what matters. So, this has happened someplace in your county, an inventory of the property assigned has been deposited. So whoever is on that piece of paper in there is the one that um, either has the deed of trust, and that's who you need to talk to because they're the one doing the inventory of the property and making a deposit of it. Or it could actually be that all this is sitting with the clerk of the court of the county because when you think about it, the property should never leave the county. Well, the land shouldn't. Of course, we're not talking about the land, we're talking about the res. So, okay, I'm going to turn it off here. Hope that's helped somebody. Good luck. See ya.